Welcome to your deep dive on oil and gas assignments. You know those legal documents that transfer rights? We're about to uncover why those important but dry papers are actually the backbone of some seriously big deals.
It's true. You might not think a stack of legal jargon could be thrilling, but believe me, messing up an assignment can lead to consequences juicier than any oil tycoon drama.
Okay, you've got me intrigued. We're diving into highlights from the Assignments That Won't Come Back to Bite You webinar, right?
That's right.
Let's start simple. What exactly I use assignment in this context? We're not talking about homework here.
Definitely not homework, no. Think of it like this. You're selling the right to drill for oil, not the land itself. An assignment is like that deed transfer, but for the invisible yet super valuable right to extract those resources.
So it's kind of like selling the goose that lays the golden eggs, not the whole farm.
That's a great way to put it. And just like with a deed, accuracy is everything. Imagine you're about to buy that golden goose right, but the paperwork's messed up. You could end up in court fighting for something you thought you bought fair and square.
Our source, Alyce Hoge, really hammered home the importance of getting things right from the get-go. Why is that so crucial? Can't you just, amend a document later?
You can try, but it's not always that easy. A mistake, even a tiny one, can spiral into what we call title failure.
Title failure.
Yeah, I mean, you're trying to sell something you don't legally own. Poof. Deal's off, money's tied up, lawyers are on speed dial. It's a mess.
Ouch. Talk about a deal killer. What kind of mistakes are we talking about? Is it typos or something more serious?
It could be something as simple as a wrong legal description. Picture those property lines from your neighborhood, mix those up, and suddenly nobody knows who owns what.
That's a recipe for a neighborhood feud, let alone a major oil and gas dispute.
Exactly. And it gets even more interesting when you factor in the legal layers. We're dealing with both real property law, and contract law, each with its own set of rules.
Okay, let's unpack those. Real property first. What are the key things to remember?
Think of it as the foundation. Real property law says these deals must be in writing to be legally binding. That's the statute of frauds in action, making sure everything is documented and official. Then for extra security, especially if a dispute ever arises, that agreement needs to be recorded publicly.
Makes sense. You want a crystal clear paper trail for something this important. What about the contract law side?
This is where things get really detailed. We're talking about the four corners of the document rule. Sounds intense, right?
Four corners of the document. It sounds like something straight out of a legal thriller. Break that down for me.
Well, it basically means that whatever is written in the contract, and only what's written in those four corners of the page, is what holds up in court. Got side agreements in emails or texts. Too bad. If it's not in the official document, it doesn't exist.
So no more back-of-the-napkin deals. Got it. Everything needs to be spelled out clearly in the contract itself.
Exactly. And on that note, another thing to keep in mind, if there's ever a dispute and the language in the assignment is unclear, courts usually side against the person who wrote it.
Wow, talk about high stakes.
Oh, man.
Because it's in everyone's best interest to be clear, concise, and avoid any legalese loopholes.
Absolutely. Now, we've been talking about oil and gas, but you might be surprised to learn there are actually different types of assignments out there.
Really? I thought it was just one size fits all.
Right.
What other kinds of assignments are there?
You've got your standard oil and gas lease assignments, which are the most common. But did you know you can also have assignments for royalty interests, overriding royalty interests, working interests, even specific well bores?
Wow, hold on. So you're saying I could sell the rights to just the profits or even just a tiny part of the whole operation? It's that granular.
You got it. Assignments can be as broad or as specific as you need them to be.
It's like a choose-your-own-adventure for oil and gas deals.
Yeah.
That said, with all these variations, are there some common elements that every single assignment needs to be legit?
Absolutely. No matter what kind of assignment you're dealing with, you need a few crucial ingredients. Clear identification of the parties involved, who's giving and who's getting, a precise legal description of the property, a clear statement of exactly what's being transferred. This is where things can get tricky and mistakes can be costly. All the right signatures and the proper acknowledgments according to state law.
So it's all about those crucial details.
Yeah.
No room for sloppy paperwork here.
Yeah.
It makes you realize how important it is to have an expert on your team who can navigate this stuff.
Absolutely. Now, about those experts, our source, Alyce Hoge, offered some really helpful tips for drafting and reviewing assignments based on her years of experience.
Sounds like we're about to get some insider secrets.
Alyce really knows her stuff. One of the things she emphasized was the importance of understanding those prior assignments, the ones that came before you in the chain of ownership.
Right, because it's not enough to just check if an assignment exists. You need to really dig into the details.
Yeah.
What kind of things should you be looking for? What can trip people up?
One word: restrictions. You need to know if any previous assignment put limits on how those rights can be transferred going forward. It's like inheriting your grandma's antique china cabinet.
There you
It
go.
comes with conditions.
So it's not always a clean break. Past agreements can echo through the years and come back to haunt you if you're not careful.
Exactly. Failing to properly investigate those prior assignments is a huge pitfall. You could end up with an assignment that's about as useful as a screen door on a submarine.
Okay, that's a visual. Speaking of cautionary tales, Alice mentioned a real legal case in Texas that illustrates this point perfectly. Something about shut-in royalty payments. I'll admit, those sounded a little snooze-worthy at first, until I realized what was at stake.
Oh yeah, the Riley versus Merriweather case is a classic example of how a seemingly small detail can make or break a deal.
Refresh my memory what happened there.
It all came down to a clause about production. The assignment said the rights would revert back to the original owner if the wells weren't producing, even if the company was making those shut-in royalty payments.
Hold on, back up. For those of us who don't speak fluent oil and gas, what are shut-in royalty payments?
Good point. Essentially, they're payments made to keep a lease active even when oil and gas isn't being pumped out. Think of it like a placeholder you're paying to keep the rights, even if you're not actively using them at that moment.
Okay, so in this case, the company thought they were in the clear because they were making those payments, but the court said, nope, the contract says producing and shut-in payments don't count.
You got it. They learned the hard way that the four corners of the document rule is no joke.
Wow, that one word producing cost them big time. Talk about sweating the small stuff. It really underscores why it's crucial to have an experienced legal team involved every step of the way, right?
Absolutely. Don't try to navigate these legal waters without a good guide. Now, another area where people trip up is getting all the necessary approvals, especially when you're dealing with state or federal leases. It's a whole other ballgame.
All right, we touched on this earlier. It's not just about two parties agreeing. Sometimes you need Uncle Sam to sign off, too.
Exactly. If an assignment involves a lease from a government entity like the Bureau of Land Management or the Texas Veterans Land Board, you better believe there are procedures. Specific rules, deadlines, the whole nine yards. It's not just about the paperwork, it's about navigating that bureaucratic maze.
So it's not just lawyers. You need a team of expert form filers, too.
Pretty much. And don't even think about taking shortcuts. A missed signature or a blown deadline can have serious consequences.
Delays, fines, maybe even the whole deal going up in smoke.
Yeah.
Don't mess with the government. Now, beyond approvals, there's another biggie our source highlighted, clearly describing the interest being conveyed. Apparently, this is where a lot of mistakes happen.
It's the heart of the assignment. It's not enough to just say, here's 25%. You need to be crystal clear about what that 25% actually represents. Are we talking 25% of your personal stake or 25% of the entire ownership pie? Big difference.
Especially if you've got multiple owners, previous assignments, things can get complicated fast.
Absolutely. And this is where the Duhigg rule comes into play.
Okay, time for another legal Latin lesson. What in the world is the Duhigg rule?
In simple terms, it prevents someone from accidentally selling what they don't actually own. Say you only have the right to sell 50% of something, but your assignment says you're selling 75%. The Duhigg rule kicks in and says, nope, you're only transferring the 50% you actually have.
So it keeps everyone honest and prevents those ownership percentages from getting all wonky. Makes sense.
Exactly. It highlights why using super specific language is so important in those assignments. Instead of just 25%, you'd say something like 25% of my 50% undivided interest, or whatever the specific breakdown might be.
So when in doubt, over-explain. Better to be extra clear than accidentally shortchange yourself, or worse, promise something you don't have the right to give.
Exactly. Clarity is king when millions of dollars are on the line.
You know, this whole time I've been picturing assignments as these standalone documents, but you brought up a good point earlier about exhibits. What are those exactly, and why are they so important in this whole assignment equation?
Think of exhibits as the supporting cast, the evidence that backs up the star of the show, your assignment document.
Oh.
Maps or reports, previous assignments, those are just a few examples of what might be included.
So it's like those crime procedurals where they bring out the photos, the maps, the forensic reports. But instead of solving a murder, we're making sure this oil and gas deal is legit.
Exactly. And just like in those crime shows, the accuracy of the exhibits is crucial. Any inconsistencies between the assignment and its supporting materials can throw the whole deal into question.
So double-checking those legal descriptions, making sure all the dates match up, and ensuring those exhibits are clearly labeled and referenced in the main assignment, that's all part of the due diligence process.
You got it. It's
Yeah.
all about connecting the dots and making sure everything lines up perfectly. Now, once
Yeah.
you've got the content squared away, don't forget about those all-important signatures and acknowledgments.
Right, because even the most meticulously crafted assignment is useless without those John Hancocks at the bottom.
Exactly. It's those signatures that make it official, a legally binding agreement. And don't underestimate those acknowledgments either. They might seem like a formality, but they can be tricky. Each state has its own specific requirements for what needs to be included.
Ah, yes, the wonderful world of state-specific legal requirements. It's enough to make your head spin.
It can be a minefield for sure. That's why it's crucial to have someone on your team who's well versed in the specific laws of the state where the property is located. A good lawyer can save you a lot of headaches and potentially a lot of money down the road.
Couldn't agree more. Well, it feels like we've just about covered it all. We've gone from the basics of what an assignment is all the way to the nitty-gritty details of drafting, reviewing, and making sure those things are ironclad.
We have. And I hope our listeners have a newfound appreciation for these documents. Assignments might not be the most glamorous part of the oil and gas industry, but they play a vital role.
For sure. They're the unsung heroes of deal-making, ensuring everything runs smoothly, and those valuable oil and gas rights end up in the right hands.
Well said.
This has been an eye-opening deep dive into the world of oil and gas assignments. We hope you found it informative, maybe even a little bit entertaining.
And if you're ever involved in a deal that requires an assignment, and let's face it, in this business, you probably will be remember clarity is king, attention to detail is queen, and a good lawyer is worth their weight in black gold.
Couldn't have said it better myself. Thanks for joining us on this deep dive.